You're watching LiveLaw and this is Ostika Das. Your feedback last week meant a lot to us. We've taken all of it into account and are constantly attempting to improve your viewing experience. Keep supporting us as we jet towards our next milestone, that is reaching 400k subscribers. Moving on, welcome to another episode of Courts This Week, where we bring to you the most pertinent legal developments that happened last week from across the country. Earlier this month, notorious gangster turned politician Atiq Ahmed and his brother Ashraf Ahmed were gunned down by 3 assailants posing as journalists while the duo were being transferred to a hospital in Prayagraj for their medical examination. And since it happened while the media was questioning them, the shocking scene was caught on camera and subsequently widely circulated. The 2 murders, while in police custody, have raised a number of questions, such as how the assailants could have known that Atiq and Ashraf were being taken in for a medical examination, or why they were made to walk instead of being taken right to the hospital gate in the ambulance. A bench of Justices Ravindra Bhatt and Dipankar Datta have asked these very questions while hearing a PIL petition seeking an independent inquiry into the 2 deaths. The petitioner has also sought a probe into the 183 encounter killings which have allegedly taken place in the state of Uttar Pradesh since 2017. While the top court has not yet issued notice, it has directed the UP government to file a comprehensive affidavit on the steps taken by it to investigate the deaths of Atiq and Ashraf, as well as containing information relating to the encounter killings of the other accused in the Umesh Pal murder case, including Atiq's son Asad. Next, we turn to the Constitution bench hearing the marriage equality petitions. We will soon be releasing a detailed recap of week 2, so watch out for that. But let me give you a flavor of what has been argued this week. The petitioners have wrapped up their argument on Wednesday. Notably, Advocate Arundhati Kadju had an emotive appeal for the Constitution bench. She said that even though the centre had condemned same-sex marriage as something that will wreak havoc in society, people on the LGBTQIA+ spectrum were also members of this very society and their respective communities. Their parents also longed to see the day when their children would get married. That's why granting legal recognition to marriage of non-binary, non-heterosexual and transgender persons was so important. On the other hand, Solicitor General Tushar Mehta, appearing for the Union government, has vehemently opposed the pleas for marriage equality. The main argument advanced by the centre is that a decision that would have such profound socio-legal implications was best left to the wisdom of the legislature. Interestingly, the bench has posed questions about the extent to which the court can interfere in what was essentially the domain of the legislature. Basically, how far can the courts go when marriage and divorce are both covered in entry 5 of the concurrent list? Besides this, the bench has also asked the Union government if it was willing to grant social welfare benefits to queer couples, similar to those that heterosexual couples in live-in relationships are granted, even without the marriage tag. Yesterday, in an almost unprecedented move, a Supreme Court bench assembled at 8 in the night for a special sitting. Why, you ask? That's a long story and we've done a video breaking it down for you. But to give you a brief overview, a sitting Calcutta High Court judge had given a television interview about the West Bengal primary teachers recruitment scam. Now, on the basis of this interview, the West Bengal government has alleged Justice Abhijit Gangopadhyay, who was hearing the matter, of bias. When the translated transcript of the interview was placed before a bench comprising Chief Justice D.Y. Chandrachud, he directed the acting Chief Justice of Calcutta High Court to withdraw the matter from Justice Gangopadhyay and place it before another bench. In response to this order of the top court, the High Court judge passed an order in a suo motu proceedings directing the Supreme Court Secretary General to place before him the transcript and all other material before 12 midnight. However, the Supreme Court was not having this, and at a special sitting at 8, it stayed this order by the High Court judge. Not only this, a bench of Justices A.S. Bopanna and Hima Kohli said that such an order ought not to have been passed in a judicial proceeding in view of judicial discipline. Wrestlers have taken to the streets to protest against Wrestling Federation of India chief and BJP MP Brij Bhushan Sharan Singh, with Olympic bronze medalist Sakshi Malik and Bajrang Punia and world medalist Vinesh Phogat leading the charge. So why have the wrestlers been protesting? Several women wrestlers have accused Brij Bhushan of sexual harassment and criminal intimidation over a 10-year period from 2012 to 2022. The wrestlers first protested at Jantar Mantar in January, but eventually called off the agitation after the government assured them that it would look into the allegations. However, now they have renewed their efforts, citing the delay on the part of the Government Oversight Committee in releasing its report and the loss of faith in the committee. The wrestlers have approached the Supreme Court seeking the registration of an FIR against Brij Bhushan. On Wednesday, when this case was mentioned before a bench headed by Chief Justice D.Y. Chandrachud, Solicitor General Tushar Mehta told the court that some preliminary inquiry might be needed before the registration of an FIR. However, on Friday, the Delhi police told the Apex Court that it had finally decided to register an FIR against Brij Bhushan on the strength of the separate police complaints filed by 7 women wrestlers. Although the bench clarified that it would not be monitoring the investigation, nevertheless, it has listed the matter after a week to receive a status update. Ahead of the Karnataka Assembly elections, the BJP-led government has sought to scrap an almost 3-decade-old 4% reservation provided to Muslims in the other backward classes category in the state. Not surprisingly, this came to be challenged before the Supreme Court. Now the state government has filed an affidavit in defense of their decision. In this affidavit, the Karnataka government has said that reserving seats for one entire religion is unconstitutional, since it not only violates the mandates of Articles 14, 15 and 16 of the Indian Constitution, but also militates against the principles of social justice and secularism. Besides this, the affidavit also states that Muslims have been moved to the EWS reservation pool and as such they suffer no prejudice. Not only this, the Karnataka government has informed the Apex Court that while a conscious decision has been taken to discontinue the policy of including the entire Muslim community in the OBC category, groups within the community that were found to be backward, such as the Pinjaras, Ladafs and Mansuris, continue to enjoy the benefits of reservation as they did under the earlier regime. Whether stand-up comedian Munawar Farooqi has made you laugh out loud or seethe with anger, he has certainly been controversy's favorite child. This week saw a significant development in a criminal case against the Mumbai-based comedian. What is this criminal case all about? The allegation against Farooqi is that he had heard the religious sentiments of people as well as insulted Union Home Minister and BJP leader Amit Shah when he performed in an Indore cafe in 2021. This week, the Supreme Court directed the transfer of all FIRs lodged against Farooqi in different states to Madhya Pradesh's Indore. This was despite the counsel for Farooqi arguing that there were security concerns if the FIRs were transferred there. Notably, the Apex Court bench headed by Justice Gawai has also confirmed the ad interim bail granted to Farooqi in February 2021, making it absolute in terms of the earlier order. Last month, videos were being circulated on the internet in which Hindi-speaking migrant workers from Bihar were being attacked in Tamil Nadu. They were eventually debunked as fake by fact-checkers and the state police department, but not before causing widespread panic. In the aftermath, several FIRs were lodged against multiple people and news outlets. Among them was YouTuber Manish Kashyap, who has been named in a number of FIRs and has been detained under the National Security Act by the state of Tamil Nadu. The Tamil Nadu government has filed an affidavit before the Supreme Court in response to his plea against preventive detention. The government has opposed a plea for clubbing of FIRs on the ground that they were lodged with respect to different incidents. The affidavit reveals that only 4 videos are common across the FIRs. The government has also told the bench that the videos that Kashyap uploaded could have triggered riots and caused significant damage to life, property and the economy. Therefore, the state has said that the YouTuber cannot now seek the shelter of the umbrella of constitutional rights after disturbing public order and national integrity. The state has also said that the freedom of speech is not absolute and should be exercised with caution and responsibility. In a significant development, the Supreme Court on Friday extended the application of its October 2022 order, which directed the Delhi, Uttar Pradesh and Uttarakhand police to take suo motu action against hate speech cases to all states and union territories. So now, all states and union territories are legally bound to take suo motu action to register FIRs against hate speeches without waiting for any formal complaint. A bench of Justices K.M. Joseph and B.V. Nagaratna also said that the action should be taken regardless of the religion of the speaker. Any hesitation to act as per the directions of the court would be viewed as contempt of court, the bench warned. A Delhi court on Friday denied bail to Aam Aadmi Party leader and former Deputy Chief Minister of Delhi, Manish Sisodia, in a money laundering case connected to the implementation of the National Capital's excise policy of 2021-22. Sisodia is currently under judicial custody in the cases registered by the Central Bureau of Investigation and the Enforcement Directorate. He was also denied bail by a special judge in a case lodged by the CBI in March this year. His bail plea in that case is pending before the Delhi High Court. These cases pertain to the now withdrawn Delhi liquor sales policy introduced in 2021. It has been alleged that the policy was intended to provide undue benefits to liquor licensees. In fact, the Enforcement Directorate has alleged that the excise policy was implemented as a part of a conspiracy to give wholesale business profit of 12% to certain companies. Nearly a decade after 26-year-old actor Jia Khan was found dead in her Juhu apartment, a special CBI court in Mumbai acquitted her then partner Suraj Pancholi. Special Judge A.S. Syed cited the paucity of evidence as the ground for acquittal. Suraj was arrested on June 10, 2013, 7 days after Jia's mother Rabia Khan found her hanging in the room. A month later, he was granted bail by the Bombay High Court. On a petition filed by Rabia alleging foul play in her daughter's death, the Bombay High Court transferred the investigation to the Central Bureau of Investigation in 2014. The agency filed a charge sheet in 2015 and booked Pancholi, who has now been acquitted, with abetment of suicide but ruled out murder. In January this year, a documentary called India, The Modi Question was released by BBC, which examined, among other things, the alleged role of Prime Minister Narendra Modi in the 2002 Gujarat riots. This documentary gave rise to a lot of controversy, but we are not going to talk about that today. What we are going to talk about is how a Delhi University student was debarred from taking his examination for 1 whole year for allegedly screening this documentary that was banned by the government. In a significant development in this case, the Delhi High Court has set aside Delhi University's decision to debar PhD scholar and NSUI National Secretary Lokesh Chugh. Justice Purushendra Kumar Kaurav quashed the decision for being a violation of natural justice and restored Chugh's admission in the university. Thank you for watching. If you found this video useful, don't forget to like, share and subscribe. Drop a comment below to tell us what you thought of these developments this week. And also hit the bell icon to get notifications whenever we upload a video. And visit our website www.livelaw.in to read our detailed reports. I'll see you again next week.